Good morning. Apart from getting acquittal, the duty bound advocate always try to conduct defense so that the punishment finally, if accused found guilty, may be under uh, less aggravated offense. Like if suppose 326 trial, if there was no weapon and the doctor's opinion is not that within the definition of 320 IPC, then conviction will be under section 323. Like that 397, 394, 397 robbery with threatening dreadful weapon, if that was not proved, then you can get conviction under 394. Similarly 302, you can very well bring a conviction under 304 part 1 or part 2, sometimes 323 also. When I conducted a trial before Justice S.T. Ramalingam when he was Principal Session Judge Chennai, trial was 302, but I got conviction under section 304 part 2. But on an appeal before Justice Mageswaran, the conviction was only under section 323. This is where here, like that I have a case, AIR 2023 Supreme Court 1243, Justice Sanjay Kishan Kaul and Justice B.V. Nagarathina. Here the trial was under section 364A and 363. 364A, 363, the accused were convicted for 7 years. Therefore, they went up to Supreme Court. Supreme Court dealt the case in a different fashion and given some deep discussion about 364A, when 364A would come for punishment. So the major ingredients for 364A was his conduct give rise to reasonable apprehension that such person may be put to death, hurt or causes hurt or death. Here, they after discussing the witnesses' evidence and the child witness, the court held that there is no sufficient evidence to prove that there was threat to kill or and something intent behind threat. Ingredient of threat not proved. Therefore, 364A was set aside. 363 alone was convicted, and they were released on bail. They were released as they are already undergone 7 years of punishment. Then the most important thing, they have discussed about 216 framing of charge. For the specific offence, there should be a specific charge. Here, this 364A, the lower court did not frame the charge, attracting necessary ingredients for 364A. These all are vital aspects. But you, my dear friends, when you are before the lower court, allow the prosecution and the court to commit mistakes. Do not attempt to rectify it, stating that no specific charge, all these things. All that will work only in the appeal. Kindly mind that. If they are not doing their duty, do not try to remind them to perform the duty unless and until you are assisting prosecution. This is where this case has been dealt, and this case is AIR 2023 AIR 2023 Supreme Court 1243 and Ravi Dhingra versus State of Haryana. This is what had happened. And some discussion about the present scenario. What was the purpose of legislation, what the legislations are doing. Unfortunately, they are lack of proper advice. from legal experts or uh, the home department secretaries. Therefore, the state government forced to cut sorry figure to withdraw the 12 hours, 16 hours duty of the laborers. Another aspect about allowing mass supply of IMFL, Indian made foreign liquors, during the marriage and festivals. And however, it is a grateful. Instead of exhibiting adamancy to maintain their stand, Honorable Chief Minister very well withdrew it, and in one case he strike down certain provisions. So far IMFL supply of mass is concerned, other one so far the 16 hours are concerned, they withheld the implementation. That means processing the bill which was already passed. And I do not know, even though there were more than 200 plus MLAs, most of them, 200, may not know what to do, what not to do when the legislations are being placed for passing. And even the leaders, ministers, also they are causing hurdles, allowing the MLAs to place their argument. They should be let the democratic revolution or ideological revolution be introduced, allow, even if he is belonging to ruling political party or allied ruling political party, to discuss about any pros and cons of the legislation which is being passed or placed for a table to pass the bill. That will be fair. Once the Honorable Chief Minister prevented them always praising the ministers and chief ministers, and you also encourage them to slightly allowing them to point out the irregularities, so that a pleasant harmony of democratic systems be flourished. However, the history had seen multi-number of democratic disasters right from the Roman culture of democratic process. All things happened. At last, we are reaching 22nd century, 21st century. Then there should be some different mode of so that these things may not happen. And one thing is there, so far the laws which are affecting public, before placing the bill, any drastic change of present system, it is far better that this government may circulate the entire bill to the common people, the people of Tamil Nadu, and allow them to place their protest or encouragement or amendment, whatever may be, or any suggestions, so that the something could be done. Because every secretaries, deputy secretaries, and other are not 100% concentrating, except attempting to please the government key holders. This is what I felt. So it is far better that there should be some website in which the bills must be placed, because unfortunately we elect our legislative representative only on imposition of ruling party, and the ruling party was supposed to select sometimes some muffs because of their loyalty to them. So all these things should be checked. Otherwise, we cannot be proud that we are in democratic system of ruling the people. Best wishes.